Intellectual property rights are the legal privileges granted to the inventor or creator to safeguard their intellectual work in the arts, sciences, literature, etc. for a specific period of time. These legal rights grant the inventor or creator or his assignee the sole right to fully exploit their invention or creation for a specific amount of time. These intellectual property rights are outlined in Article 27 of the Universal Declaration of Human Rights, which grants the right to gain protection for one's material and moral interest as a result of the authorship of works of science, literature, or the arts. The significant body that oversees the global protection of IPRs, the World Intellectual Property Organization. It oversees the first international treaties to acknowledge the significance of intellectual property, which were the Paris Convention for the Protection of Industrial Property and the Berne Convention for the Protection of Literacy and Artistic Works. Intellectual property rights objective. The term intellectual property refers to any original work of the human mind, including those in the arts, science, literature, technology, or other fields. Intellectual property rights are granted by considering the following objectives: allowing people to profit financially or gain popularity from their inventions and creations, to promote an environment where creativity and innovation can thrive by striking a balance between the interest of innovators and the larger public interest, to protect traditional knowledge. Intellectual property rights type. Traditionally, the two main categories of intellectual property rights are copyright and rights associated with copyright and industrial property. Industrial property includes trademarks, geographical indications, industrial designs, and trade secrets. Patent in intellectual property rights. When an invention satisfies the requirement of general novelty, non-obviousness, and industrial or commercial application, a patent is granted. Products as well as processes are eligible for patent protection. A patent gives the owner the authority to decide whether or how others may use an invention. In exchange for this privilege, the holder of the patent publishes technical details about the invention in the patent document for public consumption. Copyrights. The legal term copyrights is defined as the ownership rights of authors and artists over their creative works. The works protected by copyright can include computer programs, databases, advertisements, maps, and technical drawings, in addition to books, music, paintings, sculptures, and films. Copyright protects the author's right to literary and artistic works for at least 50 years after the owner's death. The right of performers such as actors, singers, and musicians, phonogram producers, and broadcasting organizations are all safeguarded by copyright and related rights. Trademarks. A trademark can be defined as a symbol that can be used to separate the products or services of one company from those of another company. Trademarks have existed since the earliest days when artisans would sign or mark their creations. Industrial designs. Industrial designs represent the decorative or aesthetic component of an object. The designs can include two-dimensional elements like patterns, lines, or colors, and three-dimensional elements like the shape or surface of an object. Geographical indication. Geographical indication and application of origin are labels applied to products that have a particular geographical origin and that have qualities or reputation or other characteristics that can primarily be linked to that location of origin. The name of the location where the goods were made is most frequently included in a geographical indication. Trade secret. Trade secrets are intellectual property rights on private information about a product like Pepsi that can be licensed or sold. It is considered an unfair practice and a breach of trade secret protection when others obtain, use, or disclose such secret information without authorization in a way that is inconsistent with honest commercial practices. International bodies, conventions on intellectual property rights. To safeguard intellectual property rights, the international community has come up with various conventions and established bodies as listed below. World Intellectual Property Organization. The promotion of the global protection of intellectual property rights is the responsibility of the World Intellectual Property Organization. It also supervises the following treaties and conventions. Paris Convention for the Protection of Industrial Property, 1883. In its broadest sense, these conventions covers all forms of industrial property including patent, trademarks, industrial design, utility models, service marks, trade names, geographical indications, and the stripping of unfair competition. It was the first significant action taken to assist creators in making sure that their intellectual property was protected in other nations. The provision of national treatment was established by this convention. Berne Convention for the Protection of Literacy and Artistic Works, 1886. It is a convention that covers copyright internationally. The convention covers the rights of authors as well as the protection of works. Budapest Treaty on the international recognition of the deposit of microorganisms for the purposes of patent procedure. The Marrakesh Treaty, which is overseen by World Intellectual Property Organization, facilitates the creation and international transfer of books that have been especially adapted for those who are blind or have visual impairments. It accomplishes this by defining a set of restrictions and exclusions from conventional copyright law. Patent Cooperation Treaty, 1970. It offers a standardized process for submitting patent applications to safeguard invention in all of its signatory states. It focuses on making the world accessible, streamlining the process of meeting various formality requirements, delaying the significant costs related to international patent protection, and proving a solid basis for patenting decisions. TRIPS, Trade-Related Intellectual Property Rights Agreement, 1994. The TRIPS Agreement is one of the most significant agreements of the World Trade Organization. At a broad level, it covers copyright and related rights of performers, record companies, and broadcasting organizations. Trademarks including service marks, geographical indications such as appellation of origin, industrial design, patents which protect novel plant varieties, integrated circuit layout designs, and undisclosed information such as trade secrets and test data. The agreement's three primary characteristics are standards. The TRIPS agreement specifies the minimum standards of protection that each member must offer with regard to each of the primary intellectual property domains that it covers. The subject matter to be protected, the rights to be granted, the permissible changes from those rights, and the minimum length of protection are all defined as the essential components of protection. Enforcement. Intellectual property rights enforcement on a domestic level is addressed by enforcement processes and remedies. The agreement establishes a few broad guidelines that apply to every IPR enforcement processes. It also includes detailed provisions on criminal procedures, special requirements related to broader measures, interim measures, and civil and administrative procedures and remedies, dispute settlement. According to the agreement, differences among WTO members regarding observance of the TRIPS obligations are resolved through the WTO dispute resolution processes. Furthermore, the agreement stipulates fundamental concepts like national and most favored nation treatment. Intellectual property rights in India. Since the inception of intellectual property rights, India has been committed to their preservation in domestic as well as international frameworks. Kapila, a systematic comprehensive effort called Kapila Kalam Program for IP literacy and awareness, addresses the current barriers in the innovation ecosystem, particularly in our HEI. This program will raise appropriate awareness among students and faculty of higher education institutions about the value of filing IP, the processes involved, and the laws governing IP filing in India and worldwide. International membership. Being a member of the World Trade Organization, India is committed to agreement on trade-related aspects of intellectual property TRIPS agreement. India is also a member of the World Intellectual Property Organization. Legal provisions. The legal provisions for various types of intellectual property rights are Indian Patent Act. The law that oversees patents in India is the Patent Act of 1970. The Indian Patent Act is administered by the Office of the Controller General of Patent Design and Trademarks or CGPDTM. Its major amendment was in 2005, Design Act of 2000. The Act protects, supports innovation and serves to safeguard both manufacturers and consumer interests. Trademarks Act of 1999 and its amendment of 2010. It has unique clauses associated with trademark registration internationally. Within 18 months, an international application may be filed in India to extend protection to the specified nations. The Geographical Indication of Goods Registration and Protection Act 1999, a law to improve the protection and registration of geographical indications associated with products. Also, there are various guidelines related to patent, trademarks, and geographical indications. Cell for IPR Promotion and Management (CIPAM) was established in order to advance the implementation of the National Intellectual Property Rights Policy 2016. It operates under the Department for Promotion of Industry and Internal Trade, ensures targeted action on IPR related issues, and attends to the policy's 7 stated objectives. In addition to taking action to promote IPR awareness, commercialization, and enforcement, CIPAM helps to simplify and streamline IP processes. National IPR Policy 2016. It unifies all IPRs on one platform. It establishes a formal system for implementation, oversight, and evaluation. Importantly, it also seeks to incorporate and modify best practices from around the world for the Indian context. In addition, it gives communities more power to advance their traditional knowledge, regulate its users, and profit from its commercial exploitation. Advantages of IPR. The main advantages of intellectual property rights is to encourage and protect the creation, distribution, and offering of new goods and services that are based on the development and use of inventions, trademarks, design, creative works, and other intangible assets. Economic growth, giving statutory expression to the creators' economic rights and fostering fair trade. Intellectual property rights can support economic growth by fostering economic development. IPRs can generate income not only from direct marketing but also by licensing them to third parties. Fostering of culture. Copyright allows authors, performers, producers, and other creators to receive an economic reward for their works that enrich cultural heritage, enhance cultural diversity, and benefit society as a whole. These creative industries include publishing, music, and film. Technical information dissemination. Any member of the public, including researchers, can use patent information even when a company, university, or research institution does not intend to use its own patented inventions. Impetus to fair competition. By allowing consumers to make informed decisions about various products and services, the protection of IPR such as distinctive science aims to encourage and ensure fair competition as well as to protect consumers. Research and development. IPRs promote R&D activities due to the financial benefits indirectly provided to the creators. These R&D facilitate two things. It facilitates the innovation and production of new technology like a new formula of drugs against any life-threatening diseases. This new technology formula after the patent period helps a large population, for example, through the development of generics. Thus, it serves the social purpose of IPR. Open source is dependent on IPR. In industries like software, open source mechanisms like general public license are common, with no contractual obligation to use a single vendor. Its benefits include reduced startup costs, quicker project launches, quicker iteration, more adaptable software development processes, strong community-driven support, and simpler license management. It's important to note that a typical GPL actually depends on IPR since it is generally a copyright license that is only valid as long as certain requirements are met. Collateral used to secure financing. IPRs, which are intangible assets, frequently aid small and medium enterprises, including startups, in their efforts to persuade outside parties to provide them with financing such as investing equity or granting loans. The financial industry, particularly knowledge-intensive SMEs, depends heavily on the valuation of intangible assets such as patents. Intellectual property rights disadvantages. Here are a few disadvantages to intellectual property rights. Extra charges for creators. It might be a bit costly to obtain protection for the first time, especially if the project is complex and includes methods, designs, and processes. Piracy. Sometimes it becomes difficult to stop someone from copying the inventory work. Even after obtaining IP protection, it becomes disadvantageous for the original creator of the patent. Decreasing quality. As time goes on, the quality of intellectual property degrades along with the rights to do it. Worldwide inequities. The laws governing intellectual properties are sometimes different. Different IP laws in different nations can result in unequal access to innovations and technologies, which disproportionately affect and impedes the development of developing countries. Costly nature of patented products. Due to high prices for patent registration, research and development, and evergreening of patents, the price of patented products like pharmaceuticals have skyrocketed. It harms the interest of the general public as they rely on these drugs. Issues regarding intellectual property rights in India. With advantages and disadvantages regarding intellectual property in India, issues that persist are evergreening. The Indian Patent Act 1970, as amended in 2005, prohibits the granting of patents for inventions involving new forms of known substances unless there are significant differences in the substance properties regarding its efficacy. These indicate that the Indian Patent Act forbids the evergreening of patents. This has caused issues for the pharmaceuticals companies. Compulsory licensing. This is when the government authorizes organization to make, sell, import or use a patented invention without the patent owner's consent. Sale is covered by the Indian Patent Act. For foreign investors who bring technology, compulsory licensing presents a challenge because they worry that sale will be abused to copy their products.